Good evening, this is Karen Harding, barrister and solicitor from Auckland. Welcome to this training session on the summary of the law and application for summary judgment by a defendant where there's no defence or no cause of action can succeed in relation to a plaintiff's statement of claim. So we're going to run through over the core points of law so that you're clear on what you're doing and why you're doing it. So the court may give judgment against a plaintiff if the defendants can satisfy the court that none of the causes of action in a defendant's statement of claim can succeed. The plaintiff needs to establish sufficient basic facts to raise at least a prima facie case against a defendant. If they can't, this is where you as counsel, or if you're a self-litigant, will want to apply for either strikeout or summary judgment. So an application for summary judgment in the District Court is under Part 12 of the District Court Rules 2014. So you want to go and look at Rule 12.1. And the application for judgment under Rule 12.2 tells you that you must make this by interlocutory application, which is pursuant to District Court Rule 12.4. And this rule states at 12.2, judgment when there is no defence or when no cause of action can succeed, subsection 1. The court may give judgment against a defendant if the plaintiff satisfies the court that the defendant has no defence to any cause of action in the statement of claim or to any part of any cause of action. 2. The court may give judgment against a plaintiff if the defendant satisfies the court that none of the causes of action in the plaintiff's statement of claim can succeed. So this is something in your toolbox kit that you get. So when you receive a statement of claim and you're reviewing it and you're thinking, well, this just cannot succeed, maybe you have got a complete defence, for example, under the Limitations Act, and there's no prospect of the plaintiff being able to argue for a postponement of time or an extension, or you've got some other really quite clear-cut defence that really can't be disputed, then you want to apply for summary judgment and or strikeout. So your strikeout is for each individual claim that a plaintiff might make against you. We'll go through the grounds for strikeout shortly. And summary judgment is where you're able to strike it all out, basically, where they've got no case against you and the court can make a summary judgment against the plaintiff in your favour. Okay, so summary judgment is not suitable as a procedure or an application for you to make if there is a credible dispute on questions of credibility. That can only be determined if a witness is in the witness box and subject to cross-examination. So if there's a material dispute of the facts, summary judgment might not be the proceeding to go with. Summary judgment shouldn't be granted in the face of a fundamental conflict. So you're making a summary judgment application where the plaintiff clearly cannot succeed in it, okay? So it's similar in that regard to strikeout. But what is the main difference between summary judgment and strikeout is that you are allowed to file affidavit evidence. And on that basis, judgment can be obtained for the defendant against the plaintiff on material other than what is contained in the pleadings. Because otherwise that's all the judge has to make these decisions on, is what is the pleadings. Because you're saying based on the pleadings, even if you take them at their highest, that they're all alleged as completely true, they still cannot succeed because of these clear defences that are irrefutable, basically. Limitations Act or something similar. So the affidavits, if you're going to file an affidavit, which is a good thing to do if you're making a summary judgment application, they must have the aura of credibility. The summary judgment procedure is not appropriate if there's material disputes of fact that cannot be resolved on affidavit. If the dispute is a legal question, then strikeout is likely to be more appropriate cause of action, summary of judgment. So you're doing summary judgment where as a defendant you have a clear answer to the plaintiff and it cannot be contradicted. And it's not possible for the defendant to amend its claim, because one of the other things is that a plaintiff could just amend their statement of claim. But to get summary judgment, the plaintiff has to not be able to do that. You have to have given it a complete defence that's irrefutable, and the plaintiff's not able to remedy their claim based on it. And then the court can grant summary judgment. So where a claim as a matter of law is untenable, you might want to apply for strikeout on that one. So the defendant must show that none of the plaintiff's causes of action can succeed. You have to be able to knock out, like Skittles, the entire claim to be able to apply for summary judgment. And as I said, an application for summary judgment as a defendant is likely to succeed if it offers a complete defence to the statement's claim. The defendant needs to have an irrefutable case on the evidence, i.e. that the plaintiff needs to be stuffed. And that's what you want to do. You want a summary judgment and or strike it out. You just get rid of it. And you can do that if they can't make their case out. If it's a legal defence, then you might want to argue for a strikeout. So in conclusion, if you're going to apply for summary judgment, it's insufficient to establish that only part of the statement of claim cannot succeed. You have to, on summary judgment application, establish a complete answer to all the plaintiff's causes of action, even if they constitute separate claims. All right? And the beauty of it is, of course, that you can provide affidavit evidence, including expert evidence affidavit. But remember, this is about evidence that can't be refuted. It doesn't require cross-examination. It can't be disputed. It's just on the paperwork. It's a paperwork kind of application. And the beauty of summary judgment is that is an open court, so do that. But it doesn't involve cross-examination. The judge has to be able to resolve it on that paperwork. Taking the pleadings at their highest, as if whatever they say is correct, that they still can't prove their case. You have a complete answer to it. They don't have a case, basically. So if you're going to apply for strikeout, which is applying to dismiss it or stay the proceedings, and you're doing it under the district court, so you want to look at Rule 15.1 of the District Court Rules 2014, which is dismissing or staying all or part of a proceeding. Subsection 1. The court may strike out all or part of a proceeding if A. discloses no reasonably arguable cause of action, defence, or case appropriate to the nature of the pleading, or B. is likely to cause prejudice or delay, or C. is frivolous or vexatious, or D. is otherwise an abuse of the process of the court. Subsection 2. If the court strikes out a statement of claim or a counterclaim under Clause 1, it may be the same or a subsequent order dismissing the proceeding or the counterclaim. Okay. If the court strikes out a statement of claim or a counterclaim under subclause 1, it may by the same or a subsequent order dismiss the proceeding or the counterclaim. Subsection 3. Instead of striking out all or part of the pleading under subclause 1, the court may stay all or part of the proceeding on such conditions as it considers just. Alright, so if you're going to be doing your application for summary judgment, you're going to need to get familiar with Part 12 of the District Court Rules Act 2014, your Rule 12.1, 12.2, 12.14, and really get your head around Rule 12.2. If you are going to be doing strikeout application, you want to get your head around Rule 15.1 of the District Court Rules 2014. Okay, the rule doesn't affect the court's inherent jurisdiction. It can still use that. A strikeout application is made by an interlocutory application. So it's a pre-trial application. They call it interlocutory. spelled Interlocutory. It's an interlocutory application which must be heard in chambers unless a judge directs otherwise. So your summary judgment application is open court. Your strikeout is in chambers. So if you're going to apply for summary judgment and or strikeout, that will be in open court because you've got two things going on. So an application for strikeout is usually made on the pleadings alone, on the assumption that the plaintiff can make out all the factual allegations pleaded. It's not for the court to resolve factual disputes. If an affidavit is not contradicted and does not contradict the pleadings, it can be considered. So you could put one in. And if you're going to do summary judgment as well, then of course you can put one in with your expert evidence as well. Affidavit evidence can be admitted showing that an essential factual allegation is plainly wrong. To strike out a claim, the court must be certain it cannot succeed and should be precluded from going forward. That's the really key point of a strikeout application. To strike out the claim, the court must be certain it cannot succeed and that should be precluded from going forward. Strikeout. The established procedure for strikeout and its criteria is being set out by the Court of Appeal in AG versus Prince, 1998, 1 NZLR 262. Okay. So the Court of Appeals has, the Court of Appeal decision here has been endorsed by our New Zealand Supreme Court in Couch versus Attorney General, 2008 NZSC 45 at 33. Okay, so there's basically 4 criteria for the strikeout. 1, pleaded facts, whether admitted or not, are assumed as true. This does not, however, extend to any pleaded allegations which are entirely speculative and are without foundation. B, the cause of action or defence must be clearly untenable. The court must be certain it cannot succeed. C, the jurisdiction is not precluded by the need to decide difficult questions of law requiring extensive argument. So if you've got a lot of legal argument, that's okay. The court should be slow to strike out a claim in any developing areas of law, particularly where there's a duty of care being alleged in a new situation and where the law is confused or developing. So the court's not afraid of dealing with the difficult questions of law, and sometimes new issues arrive. For example, you've got that Couch case. So remember, so when dealing with the statement of claim, the court's sort of got to assume that the facts that the plaintiff have pleaded are true. It's whether you've admitted them or not as a defendant in your statement of defence. But that doesn't apply when they're speculative and they've got no foundation, so you certainly stick up for your client for that. The purpose of a strikeout application, any agreement or other document relied on has to be construed in the way most favourable to the pleading. When an application for strikeout is made on the grounds of the pleadings disclose no cause of action, the onus is on the plaintiff to show a reasonable cause of action in relation to each allegation. You see, if they can't, you want to strike them out. The test is whether on the material before the court and considering current law, it has been demonstrated that the alleged causes of action are clearly untenable, that they cannot succeed. Where a claim depends on a question of law capable of decision on the material before it, the court should determine that question even if extensive legal argument is requiring where the common law is evolving, and can consider that the evolving common law. The court can consider the position of defendants who might be at risk of potential costs that could be irrecoverable in defending untenable claims. So that's something that you can put before the court. The court can review policy factors, and one example of a case that reviewed a comprehensively policy factors is Kerikeri Village Trust versus Nicholas, High Court Auckland, CIV 2006-404-5110, 27 November. That should be 2008, I think. Claims struck out on the grounds that they are likely to cause prejudice or delay, they require some impropriety or an abuse of court processes. There is no hard line in case law between the definitions or the expressions about what is prejudicial, what is frivolous, what is vexatious, or what is an abusive process of the court. The terms can be applied to basically the same conduct. An abuse of the court's process carries an overtone of impropriety. So our defendants must be able to point to prejudice, embarrassment or delay which is out of the ordinary, akin to abusive process. So Justice Richardson in Movovo versus Department of Labour, that's spelled Moevao, versus Department of Labour 1981 NZLR 464 Court of Appeal case. A quote there which refers to a United States case says, in quotation marks, "The concern is with conduct on the part of a litigant in relation to the case which, unchecked, would strike at the public confidence in the court's processes and so diminish the court's ability to fulfill its function as a court of law. As it was put by Frankenfurter J. in Sherman versus United States 356 US 369, 380, round brackets 1958, quotation marks within the quote, public confidence in the fair and honourable administration of justice, upon which ultimately depends the rule of law, is the transcending value at stake, full stop, end quote. So your transcendent value is the rule of law. So you will have an overtone of impropriety where in the claim of the plaintiff, it's something that strikes in public confidence, where it strikes at the heart of that, and it's to the gut of what's fair and honourable in the administration of justice. So proceedings have been struck out, for example, where there's no live issue or controversy to be determined and where the proceedings have lacked utility. Examples of that include Simpson versus Whakatane Court, number 2, 2006, NZAR 247, High Court. Another example is Deliu, DELIU versus Hong, High Court Auckland, CIV 2010-404-6349, 17 June 2011. Okay, so this was a dispute between two lawyers. It was struck out on the basis of being frivolous. There was a spat between the two of them. Apparently it was a sort of very weak, tenable case, but it was a proceeding not being run to serve any useful purpose and was regarded as being a complete waste of the court's time, and it was struck out. So the court also has an inherent jurisdiction to restrain vexatious and oppressive litigation, and I've got a few examples for that you might also like to look up. So it's been found to be vexatious to bring two proceedings in respect of the same matter in different courts, and there's a very famous case about that. Bank of New Zealand versus Proudfoot, 1885, NZLR 3, Supreme Court 372. So if a proceedings is commenced after the period allowed for by the Limitations Act 1950 or Limitations Act 2010, the defendant is entitled to an order striking it out, i.e. if you have a complete defence under the Limitations Act and the plaintiff is not able to get an extension or a postponement of time, then that is regarded as being a frivolous case, vexatious and abusive process, and it's a complete waste of the court's time. You have a complete defence, there's nothing to argue here. It's an abusive process because the Limitations Act applies, and that's where they have no extension. Frivolous proceedings are those with trifle with the court's processes, and that can apply to proceedings that lack seriousness, so where they lack the seriousness warranted to be before the court or something stupid. So that, they just lack the seriousness required for a court's determination. Proceedings have been struck out as being an abusive process where it's been regarded as being a misuse of judicial process. There could be various examples of that. That's where there's some sort of unfairness and there could be an undermine in the public confidence in justice. The duty of the court is to prevent an abuse, and it's not limited to fixed categories. In O'Neill versus New Zealand Law Society, that was a 2022 NZCA case 500, the plaintiff and the appellant repeatedly engaged in personal abuse of court staff and judges, homophobic, misogyny, and the judges considered this to be an abusive process and they struck it out. Attempts to relitigate matters that have already been determined is also an abusive process. Abusive process if you are making proceedings for an improper motive. So if the plaintiff has got an improper motive for what's going on, you could strike it out. Delay in complying with procedure requirements and court orders may be another grounds for an abusive process. You can get that with self-litigants don't comply with any kind of timetabling orders, have proceedings that don't make sense, can be illegible, incomprehensible, contain abuse, racism, misogyny, all sorts of stuff. So, that can be an abusive process where they don't follow procedural requirements, don't comply with rules, don't comply with timetables. The conduct of how they conduct themselves is not acceptable. It could be grounds for strikeout. Another grounds for strikeout is where the proceeding has no live issues, it no longer has any relevance, it's impossible to understand the statement of claim, or there's difficulty identifying exactly who the defendants are for each cause of action. So this can also come up when you have lay litigants filing something that doesn't make any sense. You've got to, if you can't defend the claim because you don't know what it's saying, that's another grounds for it. It's just illegible, incomprehensible, nonsense, waste of the court's time. Strike it out. So pleadings containing irrelevant material have been struck out. For example, where much of the factual material pleaded is irrelevant, including irrelevant material, and where they've pleaded extensive evidential matter. You're supposed to plead facts, not evidence. Indemnity costs have been awarded against a plaintiff, including a lay litigant, where the proceedings have been struck out for an abusive process, where it's obvious that the proceedings were hopeless in its inception. And an example of that you might want to refer to is Rapson, RABSON versus Judicial Conduct Commissioner, 2016 NZ HC 2539. So, that's it. You want to, if you can apply for summary judgment and strikeout, then you want to apply for costs, and you could make an application for indemnity costs where, the whole thing's pointless and hopeless in its inception. So I hope this helps you. So that's an outline of what you're going to be looking at in terms of points of law in relation to making an interlocutory application for summary judgment and or strikeout. And I wish you all the best with that. And I'm happy to take the training to further levels to go through relevant cases with you. You realise that if you're going to file your application for summary judgment and strikeout, do that at the same time you file your statement of defence. So you get your statement of claim, you have a certain period of time to file your statement of defence. File your statement of defence with your notice of your interlocutory application for your strikeout and or summary judgment applications, or both of them. Also your affidavit in support of that, your affidavit of anybody else with it, including any expert evidence affidavit, and make sure in your notice you also include that you want to have an application for costs, that you want to apply for indemnity costs, and then and beautiful paperwork. Put your paperwork together so it looks good. And then you will, the next step after you file that and you get your date for your hearing, you're going to need to file a memorandum of legal submissions, and then you can use this training here, and hopefully there will be a transcript provided for you, and there'll also be an ebook that you can purchase that runs over the summary of the law, and then you'll be able to refer to this in your submissions. And then there is also a vast variety of cases. You can, of course, if you are a lawyer, you can get your legal research from the New Zealand Law Society Library. You can email the librarian with the cases that you want. You can also ask for research about different topics that you're looking for, and they can provide you with a comprehensive, tailored research for you. If you're a lay litigant, that's a bit harder for you to do. You're not going to get the law library to do that for you. However, you can use these. There are some relevant textbooks that you might find helpful, which refer to cases. And I would refer you to McGeechan on Procedure by Thompson Reuters. There is an online version, of course, at the law library. You've got Sims Court Practice New Zealand, and these are all updated, and they are available online in the New Zealand Law Society libraries, and then they go through all the different relevant rules. So your first step, I guess, if you're a lay litigant, is you're going to want to look up the relevant rules that apply if it's a district court action that you're going to respond to, or if it's a high court action you're going to respond to. If you can, get legal advice and get a lawyer to help you to prepare all the documents. But if you can't afford that, you could at least perhaps go to the Community Law Centre to get some initial advice, because you really do need to get your statement of defence done and prepare your interlocutory application notice and then your affidavit, and you're going to make sure that you do that well. And then you'll have your legal submissions ready to go, and then basically have it so the paperwork's beautiful, and that will make your application when you go to argue it in person so much easier, because the judge will have read all the information in advance, and that makes everything so much easier. They've read it, they know what you want to say, you've made it clear, then you're just able to answer questions or go through any other things. So the art of beautiful, clear paperwork, beautifully numbered paragraphs, correct references to the law with the right citations is fundamentally key. You want to do a professional job. So if you're a lay litigant, there's no reason why you can't do a professional job. You have to be careful with it and keep it on point and concise, and not wander off into the trees and the woods. So you need to focus on what you're doing, particularly in a strikeout, that the plaintiff doesn't have a case. You're not arguing about the credibility of it. It's where there's no tenable case, and it just cannot succeed, and there's law to back that up. I wish you all the best.